equality is a standard our nation lives up to. It's something that we have that other countries lack. Giving all citizens of our country equal rights without discrimination or segregation is something that our forefathers wrote for us. So my main claim is that denying same-sex couples the right of marriage violates our nation's commitment to equality, and my supporting claims would be that it violates the Declaration of Independence as well as the Constitution. A couple definitions before we get started would be marriage, which according to the Merriam-Webster Dictionary, it's the state of being united to a person of the opposite sex as husband or wife in a consensual and contractual relationship recognized by law. And a second definition it gives is also the state of being united to a person of the same sex in a relationship like that of a traditional marriage. Another definition is equality, which is the quality or state of having the same rights, social status, etc. And a third definition is the civil union, which is a legal status that ensures same-sex couples specified rights and responsibilities. So my first point is that denying same-sex couples the right of marriage is a violation of the Declaration of Independence. So we've all heard the statement, all men are created equal, it's found in the first paragraph of the Declaration. It was drafted by Thomas Jefferson in 1776. So what did Jefferson mean by this statement? Well, according to Matt Brundage, an art graduate from Maryland, Jefferson's restrictive definition was people of equal moral worth and as such deserve equal treatment under the law. So by allowing homosexual couples or same-sex couples into a civil union, it would not be as equal as when heterosexuals are allowed to a marriage license because they don't contain the same rights. An example is that, according to the American Civil Liberty Union of Illinois, is couples who have a civil union will not have any of the protections or responsibilities federal law provides to married couples. These include Social Security survivors and spousal benefits, federal veteran spousal benefits, immigration rights associated with marriage, federal spousal employment benefits, right to file joint federal tax returns, exemptions from income tax, on your partner's health benefits, federal exemption from inheritance tax, and other federal protections which are denied to same-sex couples. Another thing is that marriage is recognized anywhere in the states that you go. If you want to move to another state, they'll recognize that you have a partnership and you are married with this person legally. A civil union could end at a state line. For example, if you're from Vermont and you're trying to go to Maine, your legal status as a married couple or like a couple in a civil union would not be recognized in Vermont, and trying to get another civil union there would just be the hassle that you had in the beginning all over again. And it's also more difficult to go through things such as taxes. Tara and Siegel Bernard and Ron Lieber from the New York Times Money Management created a hypothetical situation comparing both homosexual and heterosexual costs, and this is what they said. So we gave the couple 2 children and assumed that one partner would stay home for 5 years to take care of them. We also considered the taxes in the 3 states that have the highest estimated gay populations, New York, California, and Florida. We gave our couple an income of $140,000, which is about the average income in those 3 states for unmarried same-sex partners who are college educated, 30 to 40 years old, and raising children under the age of 18. And here's what we came up with. In our worst case, the lifetime cost of being gay was $467,562, but the number fell to $41,196 in the best case for a couple with significantly better health insurance and lower taxes and etc. So knowing that these differences occur, like money differences, trying to move, you can just assume that, or you would know based on this information that they aren't equal, and trying to create a separate law and saying that it's equal to marriage brings us to our next point, which is denying same-sex couples the right of marriage is unconstitutional by violating the Equal Protection Clause of the 14th Amendment of the Constitution. So we all know another statement, which is separate but equal, which was presented by the Supreme Court in cases like Brown versus the Board of Education and the Plessy versus Ferguson. And these cases were the laws of segregation when African Americans, due to their race and skin color, were instead of being combined with the whites, were put into separate schools and transportation that were said to be equal to the ones that the whites were put in. And back then, the law was deemed a violation of this Equal Protection Clause. And the clause actually states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without the due process of law, nor to deny any person within its jurisdiction the equal protection of the laws. And according to the Legal Information Institute of Cornell, this means basically that the laws of a state must treat an individual in the same manner as others in similar conditions or circumstances. So back then, the separate but equal law was deemed unconstitutional, while our nation's bringing it back again with gay marriage by creating a civil union versus a marriage, because they're creating two separate things that are said to be equal, but really it's not equal at all. So having a civil union versus a marriage license creates that scenario. And Mary Shaw, an activist on human rights and social justice, states that separate is never equal. An example presented by Shaw is also that having a separate institution for homosexual couples wanting to marry is no more equal than the black alternative to white-only facilities. She also states that true equality is not possible when you have an us versus them scenario. So the idea of separation itself just proves that it's unequal. If it was equal, there wouldn't be need to create separation. It would just be one thing. And according to the 14th Amendment, all persons are to be treated equally. And those homosexuals that are forced or only allowed into a civil union would not be equal with those allowed into a marriage. So my 2 points today were that I gave you my 2 points were that the denying same-sex couples marriage goes against the Declaration of Independence as well as the Constitution, and it falls short of our country's commitment by treating everyone with equal standards.
All right, well, you start with a term that's usually pretty value-laden, and it comes up pretty regularly in the presentation. So there are times when I think you're on the brink of value arguments, although you do phrase it as a legal argument in most of the presentation, and I think you try to stick to that most of the time. Your layout of the secondary points in a preview was okay, but it felt a little bit rushed, and I think that you did the same kind of thing when you got to the individual points. They feel a little bit abrupt. Now, at the end, I did think that you had a good summary that reminded us of what those points were, although you got a little bit lost on that last exit there in doing that summary. So that was a mild problem there. So organizationally, I think you could be a little bit sharper. I did think that you had very good testimony, evidence, and some factual data on the issues concerned with gay marriage and the rights and the federal advantages that people who are married have. I thought you did a pretty good job on that. And I like the fact that you have a nice hypothetical example that is actually calculated based on some real-world information. I think that makes the example seem a lot more practical and likely there. Like I said, I thought each of the issues was pretty well developed. I do think that when you get involved in some of the technical terminology of the constitutional issues, that you are, at times, like I said, on the brink of dealing with value arguments, and there are legal arguments about those issues, and a couple of times you had some good quotes that dealt with the legal issue, but you often didn't stay with those and you went with the other points. So you've got kind of a dual direction that you're going. Both you're headed in two directions, or the same direction, but you're taking two paths to get there. And I think maybe a little bit more focus on one would be a good idea. The delivery, I think, is okay. You are rushing because you've got a lot of material in the presentation, and maybe that's why it might be a good idea to make a choice. All right. Thank you.